Car here with an employment law FAQ. Today's FAQ: can an employee be terminated for any reason during a probation period? The short answer is no. For the long answer, keep listening. Firstly, we need to put this into context. Employment relationships are typically governed in Australia by statute, the common law, agreements or contracts of employment, and enterprise agreements or awards. The most relevant instrument to a probation period is an employment contract or an employment agreement. Typically, these will provide for the termination of employment for any reason with short or no notice within a probation period. Probation periods are often around 3 or 6 months, although they can be much longer in certain circumstances, such as in the case of academic employees of universities. Now, whilst the inclusion of a probation period and the provision of termination without cause during that probation period can assist an employer to avoid a contractual claim, it doesn't do away with the requirements of statute, the duties that arise under common law, and, if they are relevant, any requirements imposed by an enterprise agreement or award. So what does that mean practically? Well, if you'd like to sack me during my probation period, and my probation period is 4 months, and we hit the 3-month mark and you like me gone, then for the purposes of my employment contract, assuming there's a probation clause in there that says my probation period is 4 months and I can be sacked for any reason during that time, then you're more likely than not going to be in the clear as far as a contractual claim goes. If you sack me during that time, I'll struggle to bring a breach of contract claim against you because the contract provided you with the opportunity to terminate me during that time for any reason. However, I'll still have the benefit of statute and, if one applies to me, an enterprise agreement or award. Most relevant to the question of termination when it comes to statute is the unfair dismissal and general protections regimes that are imposed under the Fair Work Act. In most cases, the unfair dismissal regime wouldn't be available to me if you were sacking me at the 4-month mark, because I won't have been employed for the minimum 6 months that's required before I can bring an unfair dismissal action. So, theoretically, if you sack me within a 4-month probation period, you're okay as far as the contract goes and as far as unfair dismissal under the Fair Work Act goes. But I still have access to the general protections regime. There's no waiting period for those. So if I have a protected attribute, or I possess or have exercised a workplace right, and I've got good reason to claim that you sacked me because of either that protected attribute or that workplace right, then the existence of a probation clause in my contract isn't going to help you. Sure, I won't be able to bring a breach of contract claim against you, but I can still bring a general protections claim. What's more, if an enterprise agreement or award applies, and there are requirements in either that enterprise agreement or award around how to go about termination, perhaps with specific provisions for employees who are within a probation period, and you don't follow the requirements, or you don't meet the requirements of that enterprise agreement or award, then suddenly, whilst I don't have a contractual claim against you, I may have a general protections claim against you, and I could also claim that you've breached either your enterprise agreement or an award. So suddenly things start to look a little bit more complicated. Unfortunately, there is a bit of a myth that says you can simply terminate someone without reason and without risk during a probation period. Whilst that might be true for the case of a contract, and you'd of course need to consider the term or terms in the contract that provide for probation, that is certainly not the case when it comes to statutory and other protections that are available to employees. So the takeaway is this: even if someone is within probation, you must treat termination seriously and you must approach it carefully, because probation is not a catch-all, it is not a save-all, and probation doesn't simply mean that you can walk someone out the door without any care